Do small business owners have to worry about their business interests in their estate planning? If so, what happens when they pass away? My name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to try and answer some of those questions for you. You can find me on my website at www.amandarocalaw.com. You can follow along on my social media at Amanda Rocha Law, or comment down below if this platform allows you to do that if you have specific questions or would like to schedule a meeting with me to discuss your small business concerns or any other estate planning or probate issues within California. The reason I wanted to talk to you about this today is I have many clients who own part of or all of a business, and the smaller that business is, the more likely it is that they are sole owners. However, that's not necessarily always the case. And here's what I tell them when they ask me about what happens when I pass away with my business. When you have a revocable living trust, you can assign business interests to your trust, such as an LLC, single member LLC, or if you're a sole proprietor, you can give access to your trustee when you are incapacitated or you've passed away so that they can wrap up your business for you, not necessarily run it after something has happened to you. That way, somebody at least has legal access to get into what you have set up. There are some qualifiers I should mention. If you are a professional, such as a lawyer, a doctor, anybody who holds a professional style license, dentist, you may not be able to give all access to whoever your trustee is, whether that is your surviving spouse or someone else. Your industry will most likely state what you need to do in case you've passed away and who's allowed to come in and wrap things up. If you have staff members, for example, your staff members are going to likely be able to look at any of the private information you have as far as your clients and alert them that way. But you should at least check with your industry's formation rules about what you're supposed to do when you no longer can practice. For example, as an attorney, only attorneys can be owners of law firms. So you cannot leave the ownership to someone who's a non-attorney. If you want to set something up with someone before you pass away, that's the best thing you can do, and kind of allow them to understand what you have and how to transfer it. If you don't have staff especially, you'll want to sit down with them and make sure you go over where things are and what you have and how to find them. If you have staff, again, they most likely can't be owners in a professional situation, but they can assist the person that is wrapping everything up with how to access things and where they are without providing private details that maybe a non-professional couldn't see. If you have questions about this, please comment down below. You can schedule a meeting with me on my calendar directly on my website, www.amandarocalaw.com. You can follow along on my social media and make a comment or send a message. I'm at Amanda Rocha Law. Thank you.